Good afternoon. This is in the matter of formulation of new commission regulations under COMAR, Title 20, Subtitle 70, Section 9, and COMAR Title 20, Subtitle 75, Section 8 in Rulemaking Number 66. In this case, staff proposes that the Commission promulgate new regulations to establish regulations for staff-assisted rate proceedings applicable to small water and sewage disposal companies. Those regulations were made public back on August the 27th. I understand Office of People's Counsel filed comments in response, and Staff Counsel filed a response to Office of People's Counsel's comments. We'll begin with any comments by Staff Counsel.
So, good afternoon, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. With me are Juan Alvarado, Director of the Commission's Telecommunications, Gas, and Water Division, and Jennifer Karras, Regulatory Economist with the same division. Also available are Zeke Shusko, Engineer for Water and Wastewater Systems, and with the Commission's Engineering Division, who's with the Commission's Engineering Division, and David Valcarengi, Assistant Director of the Commission's Accounting Investigations Division. Staff is presenting for your consideration, as you mentioned, proposed regulations under COMAR Sections 207009 and 207508. The purpose of the regulations is to establish rules applicable to staff-assisted rate cases for small water and small sewage disposal companies under SB 218, which has been codified as Section 4203C of the Public Utilities Article. Staff-assisted rate cases will occur outside the formal case docket until and unless the staff-assisted rate case results in a settlement to which OPC is a party. As proposed, the regulations define a small water and sewage disposal company as one with gross revenues for the previous year of $350,000 or less. Staff estimates that there may be as many as 20 such companies under the Commission's jurisdiction that could qualify for a staff-assisted rate case, and we have no idea how many will take advantage of that. A qualifying company may seek staff's assistance in analyzing the need for a rate increase by submitting a letter to the Commission's Executive Director requesting such assistance together with a completed application. The application is not included in the regulations, but we have submitted it to you for your review and approval. Staff envisions this will be sufficient for most requests upon a completed filing. Staff will send the applicant a letter noting that the application has been deemed filed. There might be additional data requests and other requests of the company that go on after that. For certain, once an application is deemed filed, the Accounting Division will audit the applying company's books and records. The Engineering Division will inventory the company's facilities and evaluate the system's components and the adequacy of service being provided. And finally, the Telecommunications, Gas, and Water Division will establish a rate of return and proposed rates. Upon completion of this work, the Office of Staff Counsel, it is envisioned under our proposed regs, would prepare a report containing staff's work papers, findings, and recommendations for the Executive Director. Upon approval of the Executive Director, staff's report will be sent to the applicant, OPC, and any known community association. This is for the purposes of determining whether the proposed rates contained in staff's report can be agreed upon for settlement purposes. Upon agreement of settlement, the parties would file a stipulation in settlement supported by such exhibits as are appropriate, and together with the staff report and a request that the matter be docketed as a case. In the event there's no agreement, the small water or sewage disposal company may file a request for revision of rates under whatever statutory section of the code would apply to them. And I say it that way because there were a couple of changes made to the statute that would affect water companies this past session. I should note that the Office of People's Counsel filed comments, and as you noted, Mr. Chairman, staff did respond to those, but We have been in contact with OPC regarding their concerns. Staff would commit to copying OPC on the letters that are sent to the applicants. And in the alternative, if it doesn't delay the process due to notice issues, staff would propose adding the phrase "and the Office of People's Counsel" after the word applicant at proposed section 20700904B for water companies and 20750804B for sewage disposal companies. Staff would also commit to providing OPC with general progress updates on specific cases upon their request.
Thank you, Ms. Garofalo. Office of People's Counsel, it sounds like staff is conceding to what the People's Counsel requests. Is that correct?
Yes, with respect to notice, our comments set forth, our concerns were twofold. One was that we received notice that a case had been initiated so that we weren't caught blindly when the staff report was issued. And the second concern had to do with the fact that there seemed to be no provision for the case to terminate. Like if the company hadn't submitted required information, it could just continue on and on. That's of less importance to us, and we would leave that up to the commission to decide whether that's appropriate.
Ms. Garofalo, it wasn't clear. Were you planning just as a courtesy for having commission staff copy Office of People's Counsel on this documentation and correspondence, or are you proposing to actually make a change to COMAR?
We would not object to making a change in our proposed regulations that would provide them with notice. Our concern is whether that would hold up anything due to any notice requirements. So we're happier with the more formal option of including it in the regulations. But we would not, we're very leery of having a time frame for these cases. The companies that will be filing these cases are very small. Answering a data request from commission staff is probably never going to be at the top of their to-do list on a given day. So it's hard to anticipate how long these would take. We would certainly envision that we'd have a lot of communication with the companies that file these cases, and that we would make sure that no data was filed that was either inappropriate or that the data lingered in the case so long that it no longer was useful. But the idea of having a cutoff date for this, because there are as many as 20 companies that could file these cases, and so we just wanted to be able to manage them to the best of our ability.
And just to be clear, your proposal to provide notice to Office of People's Counsel is with respect to Regulation .04B of both water and sewer regulations?
That's correct.
Thank you. If the parties have no more initial comments, Commissioners. Commissioner O'Donnell.
Just a question on that point. And my knock on wood didn't work. So there's an application and you would get notice under the discussion at OPC. Mm-hmm. What does that mean? Does that give you standing immediately in that case? It's just an application at that point.
No, it's really more the stated goal of the regulations is to create an efficient process, and it allows us to put it onto our docket and be prepared when we do receive ultimately the staff report.
So when the staff report comes in, that's where you're getting the notice that gives you a chance to intervene or contest.
Or negotiate.
Or negotiate for settlement.
Yes.
But there's nothing, the notice up front, there's no other kind of standing conferred to you yet at that point.
I do not believe so.
Okay.
Commissioner, if I could follow up. Is it my understanding that OPC or any party would only have standing at such point when a rate case was filed by the water or sewer utility?
OPC would be involved once staff's report is complete, but not before. The company would be involved throughout the process, as would staff. Also, once the report is finished, sometimes these water companies come into existence because a developer has developed a housing development. He's had to, for whatever reason, create a water company to go with the housing development. Once he has sold all the houses, that company passes on to a different third party. And so we would have, that's why we would include the community associations once the report's finished. Before the report's finished, it's hard to know really what's going on with these companies.
Okay, so before the report is finished, the whole universe of parties that will be aware of the report is commission staff, the utility, People's Council, and directly affected customers?
I think we would not give notice to the customers when the owner of the water company asks for a staff-assisted rate case.
So, Mr. Chairman, if I could maybe clarify. So, when a request comes to staff, there's no case open, right? This is just a request for us to investigate whether even a case is necessary, right? It might be that we decide that no rate increase is necessary. So there's no real parties to any of this. This is just us being asked to write a report about our opinion as to whether a rate increase should occur. After the report is done, we've done a lot of investigation and we're ready for settlement, then a case is initiated. At that point, all of the parties can become a party to the case if they want to, including OPC. What OPC was asking for is for notice prior to that case being opened, so that they can be prepared to deal with the case portion of this process, but not before that. Once that case portion of the process is open, then every party can come in and either settle or not settle. Even the water company, if they disagree with our recommendation, can say, you know what, thank you very much, but we want to move on with an actual rate case under a separate section of statute, so on and so forth. But we envisioned us to just be working with the company just mainly for data acquisition, so that we can conduct our own review and we can conduct our own recommendation. And then that's when the other parties will be informed.
That was helpful. Thank you. Commissioner Herman.
Thank you, Mr. Chairman. I have a couple of questions, and I think I have some potential changes that I think the parties have a copy of. My first question is, why $350,000? Is that, is it because there's about 20 companies, or what's the basis for the $350,000 limit?
The $350,000 limit was included in our original report to the legislature, and the way we calculated that is because we conducted a small study that determined that companies above $350,000 had consistently been able to get rate relief in the traditional way. These are companies that are usually backed by much larger, nationwide companies, and they were consistently being able to come in for rate cases and get the rate relief they needed. So the companies under 350,000 were the ones that were having an issue with that. I think the largest company that we have left, and might be a little outdated, but the largest company that we have left that would be able to use this was the Severn Water Company, who actually is the company that has most recently completed a staff-assisted rate case in the near past, and they were well below the 350,000, and that's how kind of we gauged it. It was above where Severn was, but below where the bigger companies were.
Right. Well, I guess if 350,000 was in your report, but the legislature adopted $1 million, I'm wondering if there's, perhaps we should. Is there a possibility that we should leave it open to something more if under an application or something like that? Because it seems like if it's up to $1 million, it is in our discretion under the legislation, but at the same time we're a third of $1 million, and so I'm a little.
Yeah.
concerned with the number, I guess, just in case.
So let me give you a little bit of background. So in our original rules, or the original bill that we proposed to the legislature, there was no number. It was OPC that requested a number be added in there. And the reason why there wasn't like a million, it said, it was up to the discretion of the commission. But the reason why the million was added in there was because we said, okay, we can add a number, but it's got to be a number that definitely does not include, let's say, like a company comes in and buys like the Baltimore water system or something, that we wouldn't be doing that. Because our concern is, you take a company like, let's say, Artesian Water, not the largest water company in the state right now, but also not the smallest. If they were to come in and ask for this, this is not a small case. This would be like a lot of paper, a lot of accounting, a lot of auditing that, frankly, staff just doesn't have the resources to complete in the way this envisions. So we took those companies that we know we have the resources to help efficiently, and that's how we came up with 350,000. The 350,000 was floated at the legislature, and the legislators understood where our position was with the 350,000. It's just that OPC wanted an actual number that was much higher, and we just said, okay, fine, we couldn't add a number, but just we don't want it to make it so large that if WSSC, all of a sudden the law changes and all of a sudden we regulate them, that we would have to do this for them.
Okay, that makes sense. Do you think that we need to consider, now that we have the law that enables the purchase of smaller water systems with the fair market value provision, have we adequately protected ourselves from making sure that a large company doesn't come in and take advantage of this because they're that small entity, even though it's owned by a larger water company, is 350,000? Do we need to protect ourselves? Have we protected ourselves from that so that staff is not out there, with some, helping out somebody,
Right.
an entity that may absolutely have the, at least nationally, the resources to do this?
Right. So the way we've envisioned this, has to do with their annual reports. So if you file separate annual reports, like for example Mr. Crooks does, he files a separate annual report to each one of his systems. Each system will be considered individually. Something like Pinto and Highland, who are two separate systems but that file a combined annual report. Highland Estates is a very, very small system. I think it has 40 customers on it. But they file with Pinto, which has 1,000 customers. And so we treat them as one company. And so if a large company was to come in and consolidate that in there through a fair market value, then that would become a part of their company. It would just be a bigger company. They would have to proactively say, as part of the fair market value, we're going to keep this company separate.
Okay. So we don't have a problem.
So we don't have a problem. In addition to which, all the largest companies in the state, their stated goal is to consolidate.
I get that, but just sort of belt and suspenders kind of a thing.
Yeah.
It just occurred to me, like, well, if somebody did that, we don't want our staff,
Right.
being used for a staff-assisted rate case when the entity probably has its own resources to be able to do that. Okay.
And as a staff member, I appreciate that very much.
All right. So you'll see that on 04B, you just suggested, Ms. Garofalo, that we send the applicant and the Office of People's Counsel written notice the application's been received. Is that right?
Correct. That would be after
the applicant?
After applicant.
Right. Well, I personally don't have an issue with that, but it does say that the staff-assisted rate case will be deemed filed. Is that should we revise that word? You'll see that later on upon the filing, because it's not really filed. It's I don't know. Is it filed? That was one of my questions. Is filed the right word, or do we need to be more precise?
We wanted, here's the problem we were trying to solve, and perhaps it was inartfully addressed by me. I can give you an example of someone who actually completed a water case under Policy 14 about, I think it may be 2 years ago now. But this process began about 4 years earlier, and maybe even longer than that. The applicant came in and met with the Water Division and Staff Council Division and said they wanted to file such a case and asked a lot of questions. There was back and forth, exchanging of information, and then that person was not heard from for 2 years. After which they came back, they said, well, here's my information. At the time, they didn't have their annual report filed, so that took some time. So what we were trying to have a system whereby you haven't actually filed, for want of a better word, one of these until you've completed the application.
Oh, I get that. I'm
Yeah.
just stuck on the word.
Yeah.
Because when I think of filed, I think of being filed with the commission. And as Mr. Alvarado just said, these things aren't filed, don't become an active case until they are completed and everybody's looked at it and hopefully they've reached a settlement. So what I was trying to, I missed that word, that filed, but I caught it somewhere else. So I was just trying to determine if there might be, is that a problematic word or is it not really problematic?
Well, we could say that it could be deemed formally submitted, or we could perhaps
Deemed submitted or something
deemed
like that?
submitted for
Okay.
and ready. And the idea, what we're looking for is when staff needs to begin
Right.
begin its work.
Right, okay. All right, so then on C1, the concern was that by putting 10 business days into a regulation, if you've got a small entity, it may take more time than 10 days, and the last thing this commission really wants is a bunch of waivers saying I can't answer in 10 days, I need 30 days.
Oh no, yeah.
So-
We're definitely on the same page on that one.
So therefore, I just said, and in your letter, of course, you could say, provide responses within X number of days, whatever you feel
Right.
the staff feels is appropriate for that set of questions and for that entity, because it may vary.
Right.
So that was just sort of a change. Anytime I see any kind of a days in a regulation, I'd rather not. If I can avoid putting it there, I'd rather
Yeah,
do
I
that.
think
So okay. So I guess in 05A, I was just messing with the word filing there, because it just
Right,
made me uncomfortable. So we could say procedures for a rate case are something like that. It's just that was just for that change there. And then the next change, which is in 05A4, I felt like when I was reading these regulations, the applicant was gone. And I understand that the applicant may not do any of the work. I understand that staff does all the work, and I'm sure the applicants are very grateful. But at some point, I thought that the applicant shouldn't the applicant accept it or, say, here's the results, this is where we came up with. And it seemed like it was going to the executive director as sort of a done deal at the same time it went to the applicant. So therefore, the change was first to go to the applicant for its review and acceptance, and then upon the acceptance, go to the executive director.
So
I'm not sure if that makes sense or not, but and I'm sure you anticipate that the applicant is involved and you're discussing it, but
right.
the regs did not envision any participation by the applicant.
Right. So I think we agree with you that it should go, before it goes to OPC and to the potential ratepayers, it should definitely go to the applicant. And of course, occasionally we have one of these and we look at the things and we decide that they aren't entitled to a rate increase.
Mm-hmm.
In that case, it would definitely go to the applicant. We thank you for your change. The only thing we would need to want you to understand, I'm not sure whether it needs to be included in the regulations, but of course, as staff, our work would be funneled through the executive director, and so we would, before we sent the applicant anything that we wanted, that we thought of as final, we would want a sign-off from our executive director that he agreed with us that that was a final
Oh, yeah,
product.
I don't know that this prohibits that. I just, you know, and I, you know, what sort of touched me on this was that I felt like the applicant needed to be at least mentioned in this process, and so therefore that's the way. And if you all want to try to think of a different way to do it, I'm fine with that. I just thought it should be clear that the applicant, you know, needs to be involved.
We agree,
some
and
way.
it may be that the applicant looks at it and he says, well, this is what I imagined, I think I'll just go file a rate case, or
Right.
there are a number of possibilities. Yeah.
Right.
So if I may, I don't think we could provide anything to anyone without the executive director approving it for staff, because ultimately he is the one who approves everything that we
Well,
do.
that's your internal process.
Right, and this was meant to show what our internal process is going to be as we review this. So what I was going to suggest is that if you look at B, it says upon approval by the executive director, staff report will be sent to the applicant, the Office of People's Counsel, and any other effective community association. So maybe what we should do is say staff report will be sent to the applicant, and then a second step where it's sent to the Office of People's Counsel and the community association.
And leave out the executive director because that's
Well, the executive director would come in first, and we can take him out. I mean, we have to. He has to approve it anyway.
right.
The thing is that if you look under section A, it says the work of technical staff will be coordinated by all of these divisions.
Right.
And so our point was all of these divisions put it all together, but ultimately it's the executive director who approves it,
Right.
and that was our goal. But I definitely understand your point. I think that the applicant should be, you know, the first person to learn of the fate of their application.
Right. So what was your suggestion?
So what I was suggesting is in section B, staff's report will send to the applicant, period. You know, maybe we can add
Following agreement.
following agreement or whatever, the Maryland Office of
Wait a
People's
minute.
Counsel.
We're in 5B?
5B, so after applicant, you would add a period.
Will
and
be
then-
sent- upon approval from the staff's report will be sent to the applicant, period.
Right.
Okay.
You know, upon agreement, at that point, the applicant can say, yes, I agree with your report, or I don't, right? If they agree with the report, then it will be forwarded to the Office of People's Counsel and the Community Association.
All right.
Or other stakeholders. So I would say upon approval by the applicant, the report will be sent to the Maryland Office of People's Counsel and any other known community association.
Okay. I think I've got that. So, so that would remain the same. Okay. Then on 06, with respect to the stipulation and settlement, it seemed that, you know, you were proposing to send to the community association once you've got your results. You were going to send it to the community association in 05B, but in the stipulation and settlement, they weren't contemplated there. And I just thought, now, I know that People's Counsel represents the residential ratepayers, but the association, I guess, you know, and OPC could object to that, I suppose, but the association could, you know, they may have, you know, a pool or something else, which would make them, you know, not a residential ratepayer, but a ratepayer nonetheless, and therefore could be potentially interested in participating in the settlement. So I just sort of said any other interested entity, just not to preclude. I didn't want it to say that these are the only people who can be in on the settlement. So if you have a reaction, if you think that that's not necessary, I just, you know.
Well, I would offer a reaction, although it doesn't necessarily mean that this is not necessary language. So I think when we were drafting these, we initially thought that we would have a broader thing, because sometimes places don't have a community association, but they might still have an interest. And our concern was, let's say maybe you have a association and it has, here's one, White Plains 67 customers. And one of those customers is really opposed to the settlement. That would stop the settlement in its tracks. So that's what we were trying to get someone who could speak for the bulk of the customers. And
I mean, do we have the right to exclude somebody who's affected by a rate increase? Do we have the right to say you can't participate in the settlement discussions? Or you don't, your voice isn't important? I mean, it can be a contested settlement, and the commission can make a determination on a contested settlement. I'm just trying to make sure that we're not precluding an appropriate entity, and if somebody wanted to, they would have to at that point intervene, presumably, and if their intervention, say it was an individual, customer, I mean, the commission could make a determination on that intervention, couldn't it? And sort of say, yes, that's an appropriate intervention, or no, it's not.
it could.
I just feel like it's, and I'm not sure that this is necessarily exclusionary. I'm not sure that this absolutely says these are the only people who can settle. But that was really my question. Should we allow for the possibility of another entity such as the association because they have a fitness center and a swimming pool? And that's not a residential customer.
I think my one concern is that the way this section reads, it says if agreement is reached amongst the applicant. So what it would mean with your edit is that every party would have to be in agreement with the settlement, given the way the language is written right now. And so I understand your point about the contested settlement, which means that we don't reach an agreement. And so I'm not sure that language is, if with your adjustment, it would say if agreement is reached amongst all of these people. So that wouldn't allow for a contested settlement. I don't think. I mean, not a lawyer, but.
Right. Well, I think, my point is, can we deliberately exclude, an interested person who might have a legitimate right to intervene? How do we
Like a local
exclude?
government came in and wanted to be a party and contest
Right.
this thing. That's exclusionary language that's there. It's problematic.
No, I completely understand your point. What I'm saying is that we might be better off if we add another sentence that says that any other party can be a party to this settlement if they so wish. Something along those lines that enables them to be a part of that settlement if they want to, or contest it if they want to. So all I'm saying is I see your point, but I'm concerned that the way the language is structured right now, it requires that all parties be in agreement.
That's right, Mr. Alvarado. If you have a contested settlement, all parties are not in agreement.
Correct.
So I see your concern with that
Right.
language.
So I guess in theory what you're saying is that, I mean, if we, we read it, if it's read that agreement is reached among those three, then anybody else could come in and file. It doesn't exclude that. So.
Correct. It just requires agreement of those three parties.
Okay. All right. I think reading it that way, looking at it that way, I think my concerns are addressed. I don't know about
Mine are not, though. So let me express mine. What if there are other parties? This agreement is contested. Why do three entities in the state get to decide? The staff, the OPC, and the applicant.
Well,
If I'm a county government, I may want to
right.
have the opportunity to either agree or disagree, right? But this doesn't allow it. It allows three parties to form and consent to an agreement. It excludes my ability to participate in that process of negotiation.
I don't think it does. And the reason why I don't think it does is because once the settlement is reached, we file it with the commission. And now a case is open, and anyone who wants to could come in and contest it. In addition to which, I would offer that we could add some language in there that allows anyone else who wants to be a part of the agreement to agree with the
I mean,
settlement.
look, I understand not wanting to have one person in a homeowners association, one of 67, throw sand into the gears. But what if you have and this is more often likely than not, what if you have 34 people who want this and 33 people who don't? That's the one I'm concerned about. And I don't know. I think we need to work on this a little bit. I'm not satisfied.
What if we would add a sentence to that language that follows, Mr. Alvarado? This may address what you were just saying and address Commissioner O'Donnell's concerns. Other parties may provide comments or contest the settlement once that settlement is filed.
And that was what I was kind of leading to, and I think I'm okay with that, personally.
Yeah, but doesn't that take away other parties' ability to participate in the formative parts of a stipulation agreement? There's some iteration that goes into a stipulation agreement. Those parties won't be part of that discussion.
Those parties would not be in the room.
Well, they could still be in the room, they just might not agree. It doesn't foreclose them from being in the room, it's just saying that these three have to agree before a settlement goes forward. And at that point, if the other people who are in the room don't agree, then the settlement can go forward, and they can do whatever they like to do, I think is the
I've seen
reading I'm hearing.
I've seen settlement agreements that were made where Office of People's Counsel didn't want to agree.
Right.
Right? We
And
see it.
therefore, there wouldn't be a settlement
Right,
under
but
this provision.
Under this provision, there wouldn't be a settlement.
Right.
It has to be, you get the big three and then anybody else. I'm not sure that there's equity there. Something's wrong with this provision. And I didn't notice it until Commissioner Herman brought it up. This discussion makes me uncomfortable with this language.
Perhaps we could probe this a little more. In the prior paragraph, which is Regulation 5B, in addition, this is with respect to the staff report and where it's being sent. We're going to send it to any, quote, known affected community association whose members are served by the applicant, end quote. We don't carry them down to the next paragraph in 6A. Is there a reason why the community association wouldn't have been a party to that settlement agreement?
Well, again, I think that goes back to the idea that this doesn't preclude them from being a party to the settlement agreement. This is just that agreement must be reached between the big three before it goes forward, as Commissioner O'Donnell called it. But I think what I want to make clear here is that we don't mean to preclude anyone to either being a part of the settlement agreement or contesting the agreement. All we're saying is we're making sure that at least OPC, the company, and staff have to be in agreement with the settlement before it moves forward into a case. That's kind of like the baseline. It's what we're setting here. It's a baseline that we at least have to agree. Now, obviously, anyone can come in and contest, and then the commission can say we agree with this other party that this settlement is not fair. But this is the way I read this, and the way I think we drafted it was to mean that this is a baseline. At the very least, these are the three parties that need to agree before a settlement agreement goes forward. This doesn't preclude anything else.
No, I understand that. It just seems like in the previous paragraph we have the big four, and then in 6A we have the big three. It just wasn't clear why the community association was included in one. They would receive the report, but not be a party to the settlement talks in 6A. And maybe I'm missing something.
So they would be included, we envision they'll be included in the settlement talks. But once the settlement is reached,
But if they're not required to be part of the agreement stipulation,
right,
who cares if they agree or disagree? The other three can agree and it's done.
well, to take your example, you can see that it's a problem to have OPC, let's assume, just for the sake of discussion, that all the customers are residential. That if, that OPC, I think, would probably have to make a call based about what the rates in the report show, and they'll have to balance the 34 versus 33 customers agreement with the rates. And I think our thought is they're able to do that, but we weren't really sure how to handle a lot of
Yeah.
individuals.
I'm not sure I know the answer here, but I do have some concerns that
Yeah.
only three parties are given special authority to create an agreement.
Well, with just the language, I'm not saying it actually solves the problem. Mr. Valcarengi suggests that we just delete among the applicant, the Maryland Office of People's Counsel, staff, and other interested entities. We just take that out. And if agreement is reached, it becomes not a great reg, but maybe it
It might
Kicks
cause
the
more
ball down the
ambiguity
road.
than we have. I don't think you can anticipate what parties may come in on some of these. Could be a municipality, it could be, who knows what it could be. Some
Well-
local authority.
there certainly are, there may be an entity that is being served by the water company that's not residential. But
It almost looks like you're giving exclusive franchise to the OPC, the staff, and the applicant to create an agreement.
When we were writing these, we also thought about it almost in the opposite, where we provided our report to a community association, but they didn't want to participate in the settlement. And then we didn't want to be restricted by this, saying you have to reach a settlement with them if they didn't want to participate too.
Right, but again,
Mhm.
I don't want to belabor this, but oftentimes in negotiations, people leverage their positions. And if you're not required to be part of that discussion because you're not listed as one of the three who can exclusively create an agreement, you can't leverage your position.
Mhm.
And therefore, you're disadvantaged by this language.
I would note also that in B, just above that, it says that you're sending it to the association for the purpose of determining whether rates can be agreed upon. And so you're already giving it to them for agreement. That's, the whole purpose of, or one of the purposes of B. So that just,
Well, but
now they may not
Let
participate.
me back up. How can you have a stipulation and settlement for a case that's not filed yet?
well, that's the beauty of of policy 14 and the new law. I mean, there's the applicant knows what he's asking for.
Right, but the way this, let me just stop a second.
Yeah.
I think the way this was given to me was, we're just going to collect information and give it back to the applicant. We're going to help them do the cursory work, and then they're going to use that as the basis for a rate case.
No, I would say.
And all the other notice provisions and all that would kick into effect later.
I would say it'd be used as the basis for creating rates that parties agree to, which is, of course, your point, that perhaps they wouldn't agree, but, and that are just and reasonable. So we're really kind of aiming to that. Right now, I think in preparing the legislation, Mr. Alvarado did some research, and he found that often with a small company, about 40% of any increase they get goes to pay for rate case expenses. So we're trying to take that out of the equation. We're set up to do this, and we would propose some rates, and if the applicant said, well, yeah, I think I could live with those, and there would be backup to show that would be possible, it would pay for rate base and operating expenses, then we would have other people, like Office of People's Counsel, looking at them to see if they agreed that those were just and reasonable rates, if there was no rate shock, and we would have the community associations. I guess we could repeat the language of B down below. It doesn't include the swimming pool and the gym. We might have to add a little something to include them, non-residential. customers.
I thought I come into inherent understanding this. Certainly don't.
Well, this is a stickler, because at the end of the day, we would hope that the applicant would not have to file a regular rate case.
If agreement is reached.
Yeah, we would hope for agreement, in which case then he wouldn't have to file a regular rate case.
Hence the importance of the discussion of who can create an
I
agreement.
agree. So we could certainly add this language. But I would think we might want to copy the language from B above, so we have the same people entering the settlement, at least not opposing it, and then we might add language about, it may be in both places, but it would be a non-residential customer of the company. There probably are, I don't think there are many, but some of these companies probably do have one or two non-residential customers.
Well,
Sorry.
I was going to suggest, instead of, why don't we, if the problem is if the agreement is reached, I mean, couldn't the regulation say that once every, the applicants agreed to it and so on and so forth, there should be discussions regarding a settlement? And if a settlement, and then if there's a settlement, without saying who has to agree to it, because it could be a partial settlement, if there's a settlement, then,
If then.
If then,
That
yeah.
was a proposal. I was going to say
sorry.
perhaps we could, on the same wavelength here, that 6A would begin with something to the effect that the applicant, OPC, and any interested party will engage in negotiations of a settlement agreement. Next sentence, if agreement is reached amongst those parties, then that agreement shall be reduced to writing, continues as is. Commissioner Herman, is that what you were thinking?
That's what I was, and then that's kind of fixes the problem I think that Commissioner O'Donnell's rightly having, that, if somebody is interested in participating, you don't want to marginalize them by saying that they're not really, their position doesn't count. And I think that does it. Does that?
I think that does it. I think that does it. What? But it's not clear to me, or it's not. What if you don't reach a unanimous agreement? What happens there? Doesn't.
I imagine, staff, correct me if I'm wrong, would the parties just file a contested settlement saying that we support and then we don't support the settlement?
It's left unstated here.
Yeah, I think the real answer to that is it depends. I mean, if you have one person who doesn't agree and everyone else agrees, it would go forward. It would be technically a contested settlement, but it would, for all practical purposes, be a settlement. If you have if there really is disagreement, then I would expect that whatever we had filed would not be what would be, that there would be negotiations, maybe a different rate would be agreed upon, or...
But at that point, it would be before the commission.
Before, in the process of reaching a settlement. There may be some negotiations. The applicant and staff would have agreed in a loose way on some rates. We would have proposed some rates. The applicant would have said, yeah, I think that would be okay. That would handle what I need.
But if you have a contested party who does not agree to that, then once the case is docketed before the commission, that's when...
Yes, certainly those people could intervene. Certainly during the settlement negotiations, OPC may well weigh in those, for those really tough choices where maybe they feel the rates aren't right, or maybe there is a disagreement among the residential customers that can't be resolved.
Commissioner Linton.
Yeah, I think that that gets us there. I was actually going to propose something different, but it probably would have caused more controversy. So.
I can live with that.
I won't do it.
Paragraph
I had a different question related to the $350,000 limit. I know that the former policy limited it at 100,000, and because of the study that staff conducted, took the number up a little bit. But the Senate bill also modifies Section 4207 of the PU article, which requires that in the past it didn't include water companies or sewage companies for rate cases under that section, but now it does. And so my question is, for those, is staff comfortable with the result that happens now as a result of this adoption of this regulation proposal, which is that any company that is above $350,000 in gross revenue, but is still underneath the 3% of the total gross annual revenue for all public service companies in the state, they have to follow the 4207 rate making process. So you're talking about ones that are between 350,000 and less than 1 million under the statute.
So you're talking about the make-whole proceeding?
Mm-hmm.
Right. So under the make-whole proceeding, under the new law, all water companies would fit under that definition.
Right.
All of the water companies we have. So, but the prerequisite to filing a rate case proceeding is that you need to have full rate case occur. So the question remains whether under a settlement we would agree to them coming back for a make-whole proceeding. So oftentimes take, for example, Columbia, a gas company that takes advantages of make-whole proceedings. Under certain settlements, we can say, you're not allowed to come in for a make-whole proceeding, and then Columbia would proactively have to agree to that, and that's happened in the past. So that would come down to those types of discussions on the settlement. But yeah, we're very aware of the make-whole section of the statute.
Okay. Yeah, it was just the same legislation that allowed this also incorporated that.
Right, and when we proposed that bill, our goal was to help small water companies through this,
Right.
and the larger water companies through the make-wholes, which is why they went hand in hand.
Okay, so as part of, so we're not incorporating the make-whole part of it in the existing regulation that we're working on here, but we just wanted to make sure that you were aware that that it was okay. All right.
I think so.
Do commissioners have additional questions of staff? I would ask at this time that Commissioner Herman just provide us a recap of the revisions that we appear to have reached agreement on today.
Okay. The first change occurs in 0904B. It would read, upon receipt of all completed materials listed in Section A of this regulation, staff will send the applicant and the office, are you the Office of People's Counsel, Maryland office, what do you want me to?
Maryland Office of People's
Maryland,
Counsel, please.
and the Maryland Office of People's Counsel. Written notice that the application has been received and the staff-assisted rate case will be deemed submitted. Okay, next. 04C1. And I'm going to make a change to what I originally proposed to make sure that we don't have something just go on forever. So I'll read it out and see what you all think. The applicant will have a reasonable opportunity, comma, not to exceed 90 days, comma, after receipt of the notice to file information to remedy the indicated deficiencies. That should at least limit our waiver request. That was because if we just left two open, it could last a year, and we didn't want it to go too far. So that was the reason for that additional change. Okay, in 05A, it would read, the procedures for a staff-assisted rate case are, colon, and then 1, 2, 3, 4, and 4. The next one, sorry. The next change would be in 05-4. The work of the technical staff. Actually, never mind. We're going to leave that one. That one's going to stay the same. I apologize. The next change is in in B. Sorry. 05B. Upon approval from the executive director, staff's report will be sent to the applicant for its review and acceptance, period. Following the applicant's acceptance, comma, the report will be sent to the Maryland Office of People's Counsel and any known affected community association members, whose members, so on and so forth. No additional changes. Okay? All right. Then in 06A would be revised to read, the applicant, comma, the Maryland Office of People's Counsel, comma, staff, comma, and any other interested persons shall engage in negotiation of a settlement agreement, period. Small s, small a, settlement agreement. If an agreement is reached, it shall be reduced to writing in the form of a stipulation and settlement with such exhibits as are appropriate, period. And that does not require unanimous settlement. That's not in the regulation. I'm just opining that I don't believe that requires a unanimous settlement. And those are the changes, which would then mirror in 08 as well for sewage disposal companies. I think they're all identical.
They are.
Mr. Chairman, I had one suggestion. I'm trying to support the language that was already proposed in section 04. Instead of, and this is in the title and throughout, the word initiation is used or initiated is used, different tenses of the same word. I would change that to development or developed, because at this point nothing it's been filed with the staff in terms of a request or a letter requesting their assistance, but a case hasn't been formally initiated with the commission yet. I think that was what some of the confusion was coming from, is that there's no actual pending rate case, no time schedules have started, no calendar has started rolling. So they're still in the phase of developing the actual case itself that will eventually be filed. Maybe development's not the best word, but I'm trying to make it clear that there's a distinction between the staff working with the company to develop the case and the actual case being filed with the commission.
No, I see your point both in the title and 4A,
Right.
because it does imply that the rate case is being initiated at that point in time,
Right.
which it is not.
I tried to look through here quick. I think there's only a couple places where it does that.
Right.
3.
So we would replace,
It would. I see it in the title.
Right.
You could say development of a staff-assisted rate case for a small water company.
Mhm.
And then in 04A, a staff-assisted rate case will be developed upon the submission of the following. And then A1, a letter requesting development.
Yeah.
I didn't see it anywhere else.
Yeah, I don't see anywhere else either. That's it.
thank you, Commissioner Linton. Do the parties have any other further comments before we make a motion? And do the commissioners? Okay.
Oh, I'm sorry, Mr. Chairman. Just that those same changes would go to
Right.
the other 08. Was it 08?
08.
75,
Right.
08. Yeah.
Thank
Is
you.
it-
Um,
Yes.
At this point, I will read the formal motion, which is rather lengthy, so bear with me. To conclude this hearing, I make a motion to publish in the Maryland Register for notice and comments revisions to establishing rates for small water companies as proposed. Those regulations are COMAR 20.70.9.1, titled Scope, COMAR 20.70.9.2, titled Definitions, COMAR 20.70.9.3, titled Waiver. The next three regulations I move to publish in the Maryland Register for notice and comments as revised. COMAR 20.70.9.4, titled Initiation, now titled Development of a Staff-Assisted Rate Case for a Small Water Company. COMAR 20.70.9.5, titled Staff-Assisted Rate Case Procedures for a Small Water Company. And COMAR 20.70.9.6, titled Stipulation and Settlement. Moving to the next subtitle, Subtitle 75. This is with regard to establishing rates for small sewage disposal companies. The Commission moves to adopt the following three regs as proposed, including COMAR 20.75.8.1, titled Scope, COMAR 20.75.8.2, titled Definitions, COMAR 20.75.8.3, titled Waiver, and finally, the following three regulations proposed as revised today include COMAR 20.75.8.4, titled Development of a Staff-Assisted Rate Case, COMAR 20.75.8.5, titled Staff-Assisted Rate Case Procedures, and COMAR 20.75.8.6, titled Stipulation and Settlement. And these proposed regulations were as filed by the technical staff of the Commission on August 28, 2018, and as amended here today in this rulemaking, subject to any non-substantive changes necessary to conform to COMAR drafting requirements. Is there a second?
Second.
All in favor? Aye. The motion is approved. This hearing is adjourned.